Thank you, Mr Speaker. I'm delighted to speak to the Legal Assistance Amendment Bill, the second reading. This bill makes changes to how the Crown-funded legal services are funded and includes legal aid, a lawyer for child and youth advocate services. Mr Speaker, this bill was deferred to allow consideration by Cabinet. And subsequently, in October last year, Government SOP proposed substantial changes to the Select Committee report, and those changes were adopted, and there will be an opportunity in the Committee of the House to discuss those. I commend this bill to the House, Mr Speaker.
Good speak.
The Honourable Phil Goff.
Mr Speaker, I was curious at the level of interjection from the national benches before, all baying while my colleague from New Zealand First was on their feet. You'd think if the National Party wanted to say something in this bill, which is so embarrassing to them, so replete with U-turns and backdowns, that they would have taken a full 10-minute call. But not one national member of Parliament fronted up to this House to take the full call to explain themselves to New Zealand why they could have got it so wrong in bringing in the Legal Assistance Sustainability Amendment Bill. Right. Maurice Williamson, who's a Liberal in the National Party, must have been intensely embarrassed that his minister, then Simon Power, brought in a piece of legislation to this country, supported and endorsed by every member of the National Cabinet and every member of the National Caucus, a piece of legislation so utterly wrong, so utterly prejudiced, so utterly extreme and mean-spirited that the Select Committee had to come back with its tail between its legs and bring back a bill that is scarcely recognisable. But I've got to say this, Mr Speaker, I congratulate the Select Committee. Select Committees should have the guts to look at the legislation introduced by ministers that haven't done their homework and throw it out on its ear if it's totally inappropriate. And, Mr Speaker, this legislation was totally inappropriate. What we've got here in this report back is a 12-page apology by the Select Committee, including members of the National Party and its allies, to say we got it wrong. And even then, Mr Speaker, they haven't taken it far enough. What I really object to in this legislation is it undermines a core principle that goes to the heart of the justice system. And that core principle is this: that justice is available for all, not simply according to your ability to pay for it. And what this legislation would have done, Mr Speaker, in order to save money, it would have denied people who could not afford justice the ability to access legal representation in court. And that means injustices almost certainly happen. It means that people who cannot afford to be represented represent themselves. And the old saying in law, the person who makes himself a representative in court has a fool for a representative. But it's not only the injustice that's done, it actually takes longer in court. It takes more of the court's time, and therefore it's more expensive. The problem with the National Party is they regard justice as a commodity which can be bought and sold rather than a right, the right of every New Zealander, regardless of their financial means, to be fairly represented in court, to have the right to defend themselves, to have the right to protect themselves against civil action, and the right to ensure that their side of the argument is heard in any criminal matter. That is a fundamental principle. It's not something that should be traded off. Yet this legislation contained at its heart a willingness by a national government, and to his eternal shame, Simon Power, to say that people will be denied justice because they can't afford to pay for it. Mr Speaker, legal aid is not freely provided in this country. You've got to be pretty low income before you're even eligible for it. I think the income threshold for people who are single is $22,000. That's barely the minimum wage, Mr Speaker. Yet the people who most need that support would have been denied it under this bill. And this bill is just an accumulation of U-turns and apologies for what the National Party got so wrong. You know, the title of the bill gave it away. It was the Legal Assistance Sustainability Amendment Bill. And one of the recommendations of the Select Committee is to remove the word sustainable, because sustainable actually meant cost-cutting, but it was cost-cutting on the basis of denying legal aid to those on low incomes without the means to have proper representation. You know, what I really object to is that this was a government that had, when it introduced this legislation, had just finished giving the biggest tax cuts in history to the highest income people in our country. So it's not rubbish at all, not rubbish at all. People like the Prime Minister gave himself literally more than six-figure tax cuts while they were cutting the eligibility of people that could barely rub two coins together to be properly represented within the legal system. Where is the justice in that? It's not socially just, it's not morally right, and in the end, even for this miserable national government, it was unsustainable, and they've had to back down. They've had to come into the House with the tail between their legs and say, this cannot be sustained. Mr. Speaker, I'm really concerned about a number of things, and the things that were in this, for example, said that an applicant could be refused legal aid if the applicant was in arrears for repayment. Now, I'm not justifying people not paying the debts they owe, but I am saying there are many, many reasons why a person might not be able to afford to repay the legal aid debt that they've incurred. It may be misfortune, it may be that they're low income, it may be that they think putting shoes on their kids' feet and food in their mouth is a little bit more important than repaying the bill that they owed to the legal aid authority. But what this bill would have done is said, OK, you've got arrears, therefore you get no assistance. So a person, for whatever reason, who has arrears will be denied the fundamental foundation of justice, which is legal representation in court. Now, I ask any one of the members on the National Party bench to justify how that was right. So finally, with pressure from the opposition parties, they've come back and they've put an interest of justice test in. Well, I want to ask Jackie Dean why that wasn't there in the first place. Why wasn't that there in the first place? Absolutely fundamental. And then they've made a half-hearted change. They were going to have a user pays charge of $100, and in their real sense of generosity, they've now cut that to $50. If $100 was wrong, why is $50 right? When we know that even a small fee can be sufficient to discourage people from seeking legal representation and incurring other costs in court. But there are other things that were particularly bad. And I think that Clause 20 was something that I cannot understand why members of the National Caucus approved this when Simon Powell brought it to them. And not one of them has got to their feet and tried to justify this. That when you were determining whether a person could be granted legal aid, you would set a threshold that would take into account the clothes that they wore, the furniture, the second-hand furniture that they would have, the appliances, the washing machine and the fridge. It would take into account the tools of trade, the very tools of trade that they required to earn a living, and these things were all to be used against somebody on the basis of their ability to get legal aid. How mean, how miserable, how unsustainable is that? Well, actually, it's not the worst thing. You know, the worst thing they were going to do is that they were going to take into account the technology that disabled people were using to give them the ability fundamentally to function in life. So if you had an electric wheelchair, that would be taken into account as an asset and as an excuse and a reason to deny people legal aid. Maurice Williamson, why did you support a piece of legislation that came into the House that contained provisions like that? They bow their heads in shame, and so they should, Mr. Speaker, because this was an appalling piece of legislation, partially repaired by what the Select Committee was able to do, and congratulations to the opposition members that sat on that committee and fought the government and embarrassed the national members into joining with them and saying these changes are fundamentally necessary. But the point remains, Mr Speaker, that this was a piece of legislation that was ill thought out, ill-conceived, mean-minded, that should never have seen the light of day, let alone be introduced as a piece of legislation before this House. It's been partly repaired, but the underlying sentiments are still there, and this Labor Party will oppose this legislation. And I now invite the next national member to get to his or her feet and try to justify the piece of legislation
the honourable member.
Speaker.
I call Jackie Dean.
Thank you, Mr Speaker. That was the Phil Goff